Manoj sir has been very kind and very gracious to take the time out today, and that too considering his very busy schedule and how entirely the week transpired. Sir is very renowned for a lot of fields of practice. Sir is very renowned in the Madhya Pradesh circle of law. Since the time we have decided upon this class, I've received too much feedback with respect to sir, and I'm quite sure that there is not much introduction which I can personally, in my respect, give about sir. But sir has been an icon. He has been a very well-known litigating lawyer with respect to his service practice, service laws. I've heard that there is no one who matches him in the entire state. But again, with respect to that, I'll also try to limit myself. Sir is currently the president of the Advocates Association of Madhya Pradesh High Court Bar for Jabalpur. Sir is also a very esteemed member of the bar, and he actively participates with respect to various such motivating and enhancing opportunities for young advocates. And along with that, sir, I very briefly hand over to you this class. And I'm sorry for having had taken 3 minutes of your time for this class.
Doesn't matter. Thank you. Keshav. In fact, this morning when last 2 days I was thinking about it as to what advice I have to give to young lawyers. I was just looking back in my own life. I started my practice in 1991, and it seems as if it was just a few days back. Time passes by, and you kind of grow with time. Anyways, I have jotted down a few things that I thought that if I had followed them in my formative days, that would have made me a better person and a better lawyer professionally. So right away, I think that there would be some questions also after this class. So as a preliminary advice to my young friends who have decided to take on the legal profession and want to become litigating lawyers, these days, legal profession is kind of has grown in such distinct manners that there are various avenues of even non-litigating practices. And when you are part of some kind of a law firm which is dealing with so many other issues, preparing documents and other things, corporate laws, and you assist them. But in any case, ultimately, at the end of the day, that's what I feel, that what you do in a courtroom, that gives you the maximum satisfaction in this profession. There may be some people differing therefrom because things have changed. So whether it's an arbitrator's chamber that you're attending and putting your points across, whether it's a court of law, right from the Mufassil courts, the judicial magistrate courts, the civil judges courts, up to the High Court or even Supreme Court. There's another request I would like to make, because I have been by and large confined to Jabalpur. This is the principal seat of High Court in Madhya Pradesh. So my advice would be more relevant to, not with regard to metropolitan cities and which have, I will confess, have much evolved legal systems and practices than hinterland. But nevertheless, I believe these few points of self-management and what you should equip yourself is bound to help anybody practicing anywhere. So the very first issue that I take up, I think I'm audible and visible as well.
Absolutely, sir.
Okay, thanks, Keshav. I will not. The very first thing I believe and I see is that there has to be some sort of input or some sort of a work to be done when it comes to personal grooming. That's the most important thing. When you enter a courtroom, when you interact with a client, when you deal with anybody as a legal professional, it's your personal grooming is the first thing that comes. What you see, the visual is very important. So I need not dilate much on, because I have seen this present generation. They know how to groom themselves. But having said that, my emphasis still would be that we have to accept and understand that legal system at the highest, from the highest up till the lower rungs, is by and large a very conservative setup. So you have to groom yourself and present yourself in rather, I should say, a classical manner, instead of going very, very fashionable or modernist about it. So that's something, personal grooming. you may tend to sport long hairs or something that probably may not work. That may be something, negative so far as you are concerned. So grooming is important. That helps you in presenting, and then being, you are in sync with that system there. The other thing is that you should not have any preconceived notions. You get exposed to what lawyers do through various movies, through what you may have read. But unless you step into the court premises and visit actual courtroom and have the feel of it, don't have any preconceived notions about it. I have seen very, very conservative, very, very dull looking courts passing such fantastic judgments, very modernistic. So don't have preconceived notions about that. There's something very unique about our profession, I will say. In other professions, let's say a doctor's profession, you do have an opportunity to watch your senior or a senior doctor or a surgeon performing a surgery, or maybe not taking instructions or diagnosing something to the patients. But that is quite personal in a sense that you attach to that person and you're learning it. In a court of law, which is a public place, let's say 50 odd cases a judge is hearing from morning till evening. And your case may be one or two of that, maybe three, if you're very successful, or maybe four on a given day. But the biggest advantage is that the other 46 cases that are going on, that is a unique opportunity of learning at somebody else's expense. It's your neck is not on the line, so is to say. So this profession gives you a very big opportunity of learning just by being there. If you are in a courtroom, my advice to all my young friends here would be, don't waste time here or there, chat amongst yourself or not be very attentive. It's if you are in that courtroom, you have that time, you just concentrate on what is going on there. The advantages are twofold. One, that how different people senior to you, your own peers, how they're putting across a point. You can, after some time, by being in that setup, by and large understand what is sought to be canvassed before a court of law. So you may not know very deeply what the facts are, but by and large you'll understand what is sought to be said. And in that manner you can have a multiple perspective. Different people have their different takes on how to put across a point. So you're equipping yourself. And the other most important thing is the reaction of the judge to all those various ways of putting up the similar thing. So how a point can be argued in a multiple manner, how it could be approached. That is kind of helping you to equip, and ultimately to help you, that assuming that you were in the shoes of that particular lawyer, how you would have done it, one. And secondly, how a judge would react to such kind of submissions. May they be on facts, may they be on law, and you can form your own opinion. And it is a very big asset for any practicing lawyer to know beforehand, by and large, the response that a court will give to a particular kind of argument. So that's a very big equipment while you're preparing your matter or going for a similar kind of a thing, and by you will learn use. So it's very important. First, I've said personal grooming. Then I've said have no preconceived notions. You will have to, it's the hard way that you have to learn. It's other people can tell you this is how it happens. All that you have to keep in mind. But the fact of the matter is, the best thing that you can learn when you are there in the courtroom itself. So how other people put across the point. So be very attentive in the courtroom. Attention has to be the 100%. Now, the other thing that I have been seeing here, but the newer lot is, I'm sure most of my young friends, you have to somehow keep on constantly working on the command of the language that you will employ, both in the pleadings as well as during arguments. That you can do, again, coming back, the best place to absorb and gather it is during course of arguments, especially when some good seasoned lawyers are arguing, or somebody whom has a flair for languages arguing, or be in a court where the judge is quite adept at employing good language and appreciating it. The other, apart from the point that I have made with regard to paying attention in the court, The other thing which I found as a young lawyer, which mistake I committed in my formative days, is that you have to somehow find out to employ your time rationally. It's these 24 hours everybody has. You, your own colleagues, superiors, everybody has that amount of hours. So you have to employ your time very rationally. By employing time rationally, I'm very directly saying that you should have some very solid time management while dealing with. It's a very, taxing profession. Once you've taken a legal profession, it's like not others. It's not like a 9 to 5 job. You're 24 hours on it, even subconsciously even while sleeping. You are thinking about it, so somewhere in your psyche, the matter that you're dealing with, you tend to get so involved if you want to go ahead in this profession. So time management is very important. You have to somehow, in your own way, because there's no universal formula to it, somehow in your own way you'll have to compartmentalize and utilize your time to the optimum. Well, the priorities, obviously the highest ought to be to the professional requirements. But having said that, I somehow feel that, in my formative days, and I still see, and I, a lot of us tend to motivate that most of the time as a young lawyer, you have to put in a hard work. You have to know. I at this point of time, after 3 decades, I started my practice in 91. And 3 years prior thereto, when I was in the law school, I started attending the court, because law school in our days used to be just 2 hours affair in the morning, and throughout the day I was free. You have to give time to yourself, your family, your own leisure, and for rest. So if this is, I'm saying this is important in a sense, because, once in your formative days, you put up this habit and there's no time management. And believe me, with the same amount of time, if it is managed properly, you have ample time for all other things in life. Being a professional doesn't mean that you cease to exist as a man or as a person or as a family man. So that balance is very important. And, these things many a times are found by force of habit. So if right from the beginning, if you have that kind of a deliberate attempt that you make to have a time management with regard to your professional and personal requirements, that will go a long way, in fact, throughout your life, to help you deal with the pressures of the profession, as also the other your personal requirements. I've just mentioned hard work. So hard work, by saying hard work, I don't mean, hard work mechanically. You may see a lot of people, even in your education days, there are your friends who, constantly reading, working. But is reading only the thing that is going to improve you? There are two things I always believed. Reading and understanding are two different things. A person may read for a lesser amount of time than you do, but he can understand it better. So I believe when you read, you understand. Initially, to form this habit, it may take some time if you're not already doing it. But you should not be mechanically putting your efforts in anything that you do, unless the key is you try to understand what you're doing. You try to understand what you've read, whatever therein has been given in. If you see the classic judgments, judgments up till 1960 in the AIR or the other journals, very complex issues of law, spread over facts, are dealt in 3 or 4 pages of a decision. Nowadays, it is norm that good judgment is not something which is lesser than 100 pages or something, and law journals are full of it. Long decisions are being made. There are a lot of other factors which go into it: our growth of law, the voluminous arguments that have been advised by both the sides, so they have to be dealt with by the judge. But I still believe that clarity, if brought while in the course of presentation, helps in the clarity in the judgment also. Because ultimately, if it was to be that both the parties are going to put their pleadings and judge has to decide, he may as well go have some help from some of the law interns, make out the points and can decide it. It has to be argued across, the point has to be put across. And that clarity can only come when a person who's arguing, a person who's prepared the pleadings which have been put forth before the court, has understood the issue. And in this context, my own experience, I've been practicing on the writ side, wherein invariably that I am representing a private party and we are against state infringement of fundamental rights. There are administrative laws, mostly service laws of central government and state government employees and officers. What I feel is that if the simpler you can make your arguments, a point, the more with ease you can argue it, the more are the chances of your success. The moment it gets a little bit complicated, and many a times it does, and invariably while your opponent is arguing, he's trying to put on and make it look that way. The advantage and the chances that you will lose your cause in a court of law, get that much lesser if your arguments are part. The more clear, the more simpler you can put across your point, the more are the chances that you'll win that case. That's been my personal experience. So I was saying about the hard work, and I said that it should not be a mechanical hard work. You have to understand what the issues are. And it can be done in this particular order. That's what I feel over the period. That the most important things are the facts in a case. A person comes to you with a certain problem, you take down the instructions. Facts are most important in that case. You may have, so many legal decisions against you, but you can distinguish most of them when they apply, because the law is very, very clear in this sense that law applies on a set of facts. And there's a slight change of facts and a good presentation. Even a judgment which looks as if it is directly against you can be distinguished. So first of all, you have to be the master of the fact. You have to take lucid and clear instructions from the client. Your facts are the most important assets while preparing a brief or arguing it. Thereafter, the next step comes, then you ought to know the statute, the law, whether it's in the form of a legislation, or is it a delegated legislation in the sense that executive made rules, regulations, statutory in character, or the last stage, that is, they are executive instructions. They're trying to fill in those gaps which the statute, law, or the delegated legislation has not covered. And the third, I've taken it in that order, would be the case laws. So first, you should be master of fact. Secondly, basically, what is the law involved on the issues, on the facts that you should be very clear on. And thirdly, the case law, if there is a similar or same kind of issue has been dealt with, how it has been decided. Okay. But all the three things put together, there's a fourth aspect of practice, the strategy as to how it is going to be argued. One, that all depends which court it is going to. There used to be a very seasoned and senior judge before I used to appear long back. And he used to tell us very bluntly from the dais that you should know the court first and then the law. His intention was that you should know how this gentleman deals with these kind of things. So it's important to know where it is going. So you have that kind of a strategy. There's another aspect of strategy. It all depends on who is going to oppose you, what kind of opposition you're going to get. So these are practical things that you will pick up along with the way. But that's very important. Many a times, your knowledge of fact, your knowledge of law, your knowledge of case laws, everything can be put apart by a seasoned senior who's standing on the other side, can make a certain statement and demolish your case entirely. I have faced that as a junior lawyer. So I'm telling you this. So in this order, facts, the statutory law, the case laws, and overall putting all this together, the strategy as to how you will present it. Now, so far as preparation is concerned, and prior, you have the brief, you've prepared the brief, you have to prepare. Apart from, while if many a times if somebody else has drafted, it becomes, I find myself, if I had drafted that matter, I had taken those instructions, it will be easier for me to argue it. In the initial days, try to argue more and more such matters of which you've had an interaction with the client, of which you have yourself taken the instructions and drafted. So that puts everything in one straight line. You are better equipped to answer things. So for that purpose, apart from the brief, get into the habit of making your notes. Now, note taking also, there's no this thing, but what I find, what I ultimately could evolve after nearly 10 years of my practice, how notes should be made, that I personally prepare a chart. The first line is the date. I call it the date chart. The Supreme Court also has the list of dates, and other courts also, we have these index, and after that index, the chronology of events, something like that, to give an insight into what is in the brief. But apart from the brief, you should have this personal note from which you are going to argue. And obviously, it will be much, much smaller than the brief which you have prepared. The date in the first column. In the second column, you keep the page number and paragraph wherein this fact is pleaded. Because in the most of the courts these days, the snap question that comes up, if you're arguing something, where have you pleaded it? And the more easily and instantly you're able to answer that, the more positive impression it gives to the judge. The third column should be if there's any document connected with your pleading, which is that annexure number and which is that page number in your paper book. And the fourth is the description that you want to give. So while taking notes from your client, if you have this kind of a chart prepared, so it will save you a lot of time. The same thing which was your first, starting point, so as to say, the first sheet on the drawing board would take you to the last point of arguments. And you have to suggest simply when the brief is made, to just simply put in your page numbers with regard to annexures and pleadings. And you'll be better equipped to answer, very instantly and make a positive impression on the judge. So that was a little bit about the preparation I wanted to say. There's another thing that I have seen while in the course of arguments, that we are very sure with regard to, that some wrong has been done to our client, and in the form of prayer, that this is the request we are making to the court. This prayer ought to be granted to undo that wrong and do justice. Many a times, judge, although may be convinced to a large extent, is not prepared to grant you that relief. There may be some statutory provision against it. He may say there's an alternative remedy, go there. A lot of, such things while practicing on the writ side at the high courts and Supreme Court that you may face. You should always, while making preparation, have this always invariably at the back of your mind. What is your plan B? In the event the main reliefs are not granted, can you seek for and ask for something lesser than that, which can go a long way to mitigate the grievance of your client? So that you can always discuss with your client, assuming that the main reliefs are not being granted. And as an alternative, getting the matter dismissed, can we have it, somewhere in between? Probably take it before some other authority where your client can have a chance if it's an alternative remedy issue. Or for that matter, seek that, okay, some other representation we can put in, or you don't grant me the main relief, but grant me this much, the other. So you should have a fair amount of plan B idea always. Because I have seen in the best of the cases that I have made and prepared, even while as a junior under the office of my senior, and even otherwise after being an independent counsel, and now that I'm fortunate enough to have my associates and guiding them, we should have a plan B always. So that's important, that if you're not getting the main relief, what is the other next best thing that you can get? So if you that's kind of completes the cycle of your facts, the statutory law, the case law, the strategy. In fact, this can be treated as a subsection of this strategy itself, that if you're not able to get the main relief, what else can you ask? And no matter what I or anybody can tell you about being fair, you have to be fair, you have to follow ethics, you have to have a good high mode of this thing. But at the end of the day, as a practicing lawyer, what matters is winning. Now, winning doesn't always mean 100% win in a case. Winning is always correlated to the satisfaction of your client. Even if you've lost a matter, and your client is convinced that you put in your 100% in those facts, and you've put in, argued the matter rightly, that to me is winning. There's no problem with regard to it. But it's very important that your client should have that satisfaction that you've won it. And the best thing would be that you actually won it. But anyways, if the case is so bad, you can, we can simply rearrange facts, rearrange laws, but ultimately it is that judge who has to take a call. And you should always remember that you cannot win 100%. You cannot win them all, but try to have a higher percentage of win in whatever kind of jurisdiction you are practicing. So that ultimately, helps to build up your reputation as a professional. I had, at the start of my advice to my young friends, dealt with grooming. The second thing I said with regard to preparation, that you need to be well prepared. The other thing which is very important is your conduct within and without the courtroom, outside and inside of the courtroom. Particularly in the courtroom, you have to be extremely, extremely courteous to the bench. Because ultimately, these are human agencies involved. You're not dealing with a computer or something. There's an impression, there's a man who's sitting there, a gentleman or a lady who's your judge. And all of us are human beings. If you're well groomed, your appearance is good, you're prepared, you're putting across your point nicely, and you're courteous. No, you may be well groomed, you may have put across, but if you're a rude person, you lose those two advantages. So courtesy becomes very important. And we are, as I told you right from the beginning, while dealing with the grooming aspect, we are a little bit of a conservative setup. Law is a conservative setup. And the Indian values, because you can watch a lot of American shows wherein those lawyers, they're saying anything and dealing with it, probably is part of that culture. Here in America, in India, humility is supposed to be, worn on the sleeve, and especially in, human interactions, and all the more in a court of law when you're addressing a court of law. So always remember to be extremely courteous. Now, this courtesy should not only, end at the bench. You have to extend a part of this courtesy to the opposing counsel. You have to show respect to that person. There are two advantages that you always get. First of all, it makes a very, very positive impact on the judge that you're very respectful of your counsel, of your opponent. That shows you in a very good light. Secondly, if you are addressing your opponent in such a manner that he's kind of pleased by that address, I'm not saying that he's not going to argue that matter against you, but this has been my own personal experience. It will be not argued with the same vehemence he would have argued had you been a rude person to him. So that way, you decrease the amount of attack that is coming on your way, so as to say, by being courteous. So courtesy in court. And there has to be, many a times it happens during the course of especially long arguments, contentious matters where stakes are very high, that you tend to cross, voices are raised and all that. So that can happen at the heat of the moment. But the bottom line is that you have to always understand and make it sure that you understand the difference between arguing and quarreling. So you can raise your voice, you can more emphatically put your point, if that's the way it has to be at that moment. But it should not sound as if you're fighting or you're quarreling. You're still arguing. You're still, as an intellectual, putting your point across. As I earlier indicated, that while preparing, all endeavor should be made to make your submissions easy and simple and clear for the other person to be understood. So you may, after acquiring reasonable expertise and establishing yourself, use long phrases, complicated words, but it's always prudent, when you're beginning, if your sentences are shorter, if they are simple, and if they are to the point. You may not sound, your language and everything may not sound so flowery at the beginning, but by and by you'll pick those. You can ornate your submissions with anecdotes. You can ornate your submissions with Latin phrases. You can ornate them with quotations from great men to put across, and as a repartee to something has been said, you can put across those things. But to begin with, and especially for young lawyers, it's very important that your sentences are short, they are clear, they are crisp, and they are to the point. Okay, that as I had earlier indicated, the simpler is the way that you can put across the point, the higher are the chances of your getting a favorable decision. So this is in fact a part of that when you're putting across the point, it should be in a very easy, simple, genial, and straightforward and crisp manner, hitting the issue. If you make it difficult, it becomes, it is some kind of, you are taxing yourself, because to put across something simply is as I've said, is a simple exercise, but to put across something, complicated will put more tax on you. One, it becomes all the more difficult for a judge to understand what you're trying to say, because you see, the facts have to be, they're in different realms. What actually happened is what your client knows. You are the second person to whom he narrates the story. You understand that story, you rearrange it in a legal way along with facts and grounds, and the judge is the third person. So what actually happened to what is sought to be explained and understood, they travel a long way. So I believe the biggest weapon in this, and to bring on that feeling of what actually the facts were, a simple language and easy expression will help you initially, and that is in fact some sort of a guarantee of you of winning that case, more chances of winning that case. There's another thing that apart from this preparation and other things, I have taken out in the part of your larger office management, the office which you will eventually make your own legal office. What should be the office management, how you'll be interacting with clients. It is very important as a young professional, whether you're at some other office or you have, ultimately, if you want to be in litigation practice, you have to have your own setup. So the earliest that you start to have some kind of a space that you define as office, whether at your residence or at some other place, it's very, very important that you keep regular hours. If you are to sit there, let's say for 2 hours in the evening, from 4 to 6 or 5 to 7, make sure that you are there at least 5 minutes before, available and prepared. Okay. Punctuality, and I said time management, you add punctuality to it. They always have such a positive impact on clients. The other thing is that when you are taking this instruction, if you are taking yourself the instruction from the client, you understand. If you are not, don't take it mechanically. Try to understand his point. Don't let him be very verbose, and don't let him take so much of time. You can cut him short when he's repeating things. But you ought to have an excellent communication with him at all times. Now, by all times, I mean at all stages of the litigation. The first time that person comes to you, he is a new person to you. You're taking down those instructions. And as I pointed out, if you have that kind of a date chart in front of you, taken all those instructions, then you prepare the brief, and then you do filing process through the registry of the courts, and the matters are listed day-to-day basis. Next hearing, notices are issued, replies have come in, you have to file a rejoinder, some application has come in to which you respond, or you feel that you have to file some application for something. So it's very important that all these stages, you should be the first one to have informed him of what is going on in his case. He should not be able to hear it through, or these days clients have become very smart. They'll log in and just find out what happened to their court from the court websites. Make it a point, because in three decades back, what we used to do, there was in the office that I had joined, a new clerk joined. He was a retired police constable, but hats off, that man had so much of understanding of human affairs that what he noticed, that there was always a lack of our communicating what happened to a particular case to our client. Those days, telephones, where we had one telephone in the office, but clients in the interiors or some may not have that access to the telephones. So we used to always write letters. So what this man did after 15 days of joining as a junior clerk, he was a retired police constable. He started buying those inland postcards. And every time he's preparing a new brief, he would write the address of the client on the inland postcard and a seal on the backside, and write this subject, leave that space and all, and make it all that easy for us. And they were always, tagged along with the file. So assuming I appear in his case and I got a stay in his case, all I have to do at that point of a time to, just take one sheaf of that off, write whatever I want, and just, put it in the post office of the, which was there in the High Court. So that kept him very much informed. That always assured the client that my advocate is taking such good care, good, bad, or indifferent, whatever news. Don't be ever hesitant, even if you to communicate the worst news to the client that your matter is dismissed. Be the first one to tell it to him. Try and think to, counsel him, try him, what are the other opportunities, how we can go in appeal, or can we go back and review on certain points. You have that, all this thing. So if you have this positive interaction, even if you lost a case, I have seen so many times you don't win. It's in writs also, the losing percentage is very high. When you're practicing on original writ sides, most of the time the writs finally get dismissed. But if you have this impression on the client that you got him somewhere and that his point was put across and that you dealt with his case very, very properly, even a person who's lost the case will refer people to you. I've seen that. So communication with the clients is very vital, and you should be the first one to communicate good, bad, worst, indifferent news to him. Always you can tell. Now these days things have changed because of technology. You can text him or WhatsApp him, or simply just the press, give him a phone call and tell him what has happened. So that way, whatever be the time frame or whatever be the technology which is available to us, which that communication, the better the communication, the better the chances, it will help you professionally. So also when you're about to receive a brief these days, it's become all the more easy for lawyers that when clients are contacting you, they send you, they WhatsApp you, or they email you their documents or other things beforehand. If you're able to have a look at them and be a little bit prepared before your first meeting with the client, that will have a very, very positive impression on the client. Many a times there may be such things that you may not have yet seen, some statutes or other which are involved there, and if you are in beforehand, or you have that kind of a preparation, that will be very, very, very positive. And the most vital thing which across all the ages will hold true no matter how technology develops, that you have to be absolutely truthful to your client. You should not raise such hopes that okay, this will happen, knowing it fully well that this may not happen. In fact, I can give a note of caution in this, and the little thing that I personally have started practicing from last 1.5 decades. After hearing out what the client has to say, and by our experience, because once you are in the system and dealing with those kind of matters, you tend to get that sixth sense what ultimately will happen, what kind of reliefs you can get him. You don't raise his hopes much. You don't discourage him either. Tell him these are the things that can happen. These are the kind of reliefs he can get. And in fact, if you can get him 75% of the relief, that that you can reach them, or maybe 100% is good with it. Just just be a little bit circumspect while dealing with that this is what you can deliver. So at least 10-15% less than what you are promising, it will be delivered. I can give a very good parallel of this. These companies, online companies, Amazon and other, they have this provision as to what time anything that you buy online will be delivered to you. They know it that from destination A to destination B, it will take 5 days. But why at the very inception, they tell you it's going to take 7 days. So even if it gets delayed for some reason, it's 6 days. In any case, it is lesser than the 7 days that have been promised. So, taking that example in this context, what you can get. Let's say, assuming that you can get him 100%, you tell him that 75%, 80% is your case is good, and we'll do our very best. And very candidly explain it to him. This is in all professions, there's no guarantee of what you're not guaranteeing anything. Never guarantee any outcome. Never guarantee to what amount of time that outcome will come, the kind of pendency we are having. So once you make this very clear to the client right from the beginning, he's on the same page as you are, you will have lesser difficulty in dealing with the clients, and your client will always think very highly of you. There's a very little thing, a part of this office management and your own personal grooming, your preparation, your presentation in the court. There's some sort of a code of ethics which you ought to follow. Okay. Now, ethics is such a broad topic, and ethics in different contexts would mean different thing, in different times would mean different thing, different professions would mean different thing. But there are some code of ethics. If you read the Advocates Act and the Bar Council rules and all, there's a standard set of ethics is provided, what you ought to do, what you not to do. But you make it a point that there are certain things that you will not do. For example, you will not mislead somebody to leave a particular lawyer and come to you. The example is to cite. Because if you do this thing, there's likelihood, somebody else will do the same with you. I mean, even if you don't do it, somebody else can do it. That's apart. But it will give you a right perspective in the profession. It will increase your stature in the profession. In the long run, it will be beneficial as a practicing lawyer that you have some set of ethics which you follow. Now, let me come to the last aspect. I've dealt with most of the time your office management, your personal grooming, your interaction with the clients, your presentation of the case, and the outcome. That's the professional life. What we tend to miss while we are doing it in the long run, that the family takes a backseat because it's a very demanding profession, and many a times, your family obligations are hit by it. Now, I've divided your personal life into 2-3 compartments to explain my point, better. The first thing is your health, your own person. It is very important for any professional because we are a one-man industry. Okay. For example, a doctor who's a good surgeon, everybody wants to go and get surgery from a good surgeon. Okay, he may be no matter how busy he may be, because it's a practice. He's more adapted. He's done it more times, so he's likely to succeed more. The same thing is with here. As a lawyer, the more you practice, the more better standing you'll have, the more better understanding, more confidence you'll get. So you're a one-man industry. Initially, as a young person, you can just dive down into the ocean of work and try. That's very good also, because you have to establish yourself. But by and by, and this seeds of this should come, even at that initial stage when you're doing, that you ought to have some kind of physical exercise regimen. Now we know, I need not tell you, everybody's on the internet and everywhere saying that health comprises of 3 basic things: your diet, exercise, and rest. Well, I'll rest my case at that. You have to follow some kind of a regimen which takes care of these things. And you're always in pink of health, because if you are healthy, you see this is a very strong correlation with your work also. If you are healthy, you will be able to perform your professional functions more efficiently and in lesser amount of time. So if you do the same thing, let's say in an hour with some practice, and you are adept at it, you can take instructions, understand a case in half an hour, draft it in half an hour, and then once the draft is ready, you can check it, and like 2-3 hours the court can the matter can go. But if you're not well, if your physical ailment will affect your mental well-being also. If you are not well, then it's going to affect the outcome of your work also. And it's a vicious circle that puts it. So right from your initial your younger days, where health may not be such a big concern to you because of the youth, I believe you should have a healthy lifestyle to follow and follow it. That's very important. That's got a direct correlation with your professional requirements. I advise you And everybody will say in your younger days, work very, very hard, put in your 100%. But working hard would not mean that you should do that at the expense of your health. So you have to have balance with regard to your health requirements. Rest, sleep, everything is important. I was initially hinting to that in a busy professional life, quality of family life suffers. Make sure to give and spend quality time with the family. That's very important. At this stage, as a young person, if you're not married and all your parents are there, your siblings, uncle, aunts, everything, the entire family system that we have in India. You spend time there, and this passage of time, you get married, you have your own family, your own higher responsibilities to your spouse, to your children. Try giving them some quality time from your busy schedule. That's very important. It will give you peace of mind, and it will always increase your efficiency. If you're happy, the back end of the office is fine, at your family front is fine. That will give you more efficiency, it will give you more energy, to deal with it continuously throughout your life. So these were just about some of my observations that a young professional lawyer who's planning to come into litigation, the core litigation practice, should keep in mind. I'll be very happy to take any questions.
Manoj sir, thank you so much. It was very, very enlightening, very elaborate, and I've received way too many compliments with respect to how you have actually very greatly contributed to all the participants today and people who will be joining. So as sir has said, beautiful time to ask question. I think Dr. Sai Kumar sir has a question right now.
Please go ahead.
Good afternoon, sir. Yeah, we have almost communication is very, very good. Absolutely, as if I was sitting across and talking. I felt that.
Thank you, doctor.
Very, man, beautiful means you conveyed. Only see, my question is courtesy. As I understand courtesy. What about when the judges are there? They do not show courtesy. They're discourteous.
then you go to your bar association. We get these complaints, and we try to counsel the judges as well. There are some individuals who, despite our counseling, they do not improve. But somehow you have to avoid conflict. That's most important.
And I understand, but at worst cost, sometimes we have to see. Sometimes some whimsical. You must have definitely come across. There are only two kinds of judges. There are only two kinds of judges in our country. I cannot speak about other countries. That liberal and non-liberal. Liberal is open, and then even at the last minute. But the way you have suggested, I am very impressive. That notes part, which fortunately I have been doing notes part. And also one thing I will definitely agree, sir, that sometimes I wonder in the court, even senior counsels keep on repeating same thing. That means you are not confident what you are saying.
That's right.
Because the judge cannot give any response to our contentions or arguments or points of law. He cannot say what is going to do. So keep on repeating. That is one of the. That is why what you said is precise. Precise is beautiful, and I agree with you, sir. Earlier judgments used to be very judgments. One Bombay High Court judge said, when I went for another judge's felicitation, he said, what the judge can do, like me, he said, the writ petition matter, the first petitioner said he quoted 42 judgments, all elaborate. Okay, after hearing, then other said not less than to him, he quoted 47 judgments. Where do we find to write these 100 judgments and then again give inference? So precise. So your another practice is only. May I suggest you? It is not out of it is out of topic, not your topic. You have excellently carried out your topic. Excellent. You have put across. I have. The only practical training to in law course for 1 year. Let them go to all courts. This one I have been telling every seminar, every meeting, I'm telling, so as a bar president. And second is checks and balances of judges. Like last, I'll take just a say 2 seconds. That common cause judgment, that check bouncing, entire country suffered, sir. Entire country, there, entire country. Who is responsible? Supreme Court is responsible. So only
These days,
these.
I'll just pause here. You raised a very, very important thing. Supreme Court, ultimately, that in some system you have to have some finality somewhere. In other,
Yes.
in US, let's say US Federal Supreme Court, they hear 100 to 150 cases throughout the year. It's only those questions with constitutional importance. There's a lot, of this thing of late. You must have heard in the media that people are now started thinking that the Supreme Court has to deal with only core constitutional issues, and there ought to be benches of the Supreme Court dealing with these other issues, and the largest section of Supreme Court at Delhi should be dealing with that. Those kind of things are coming. What I'm saying, that somewhere we have to come, in any litigation. Let's say you come to you filed a civil suit before a civil judge class one. You take it, you win or you lose. Your opponent will take it in the first appeal before the district judiciary, higher judicial services. Second appeal to the High Court, then SLP, under Article 136 of the Supreme Court. Somewhere
Yeah.
this needs to end. Somewhere it has to come to an end. So
Yeah.
just very, very, very nice quote, I think by some Supreme Court judge, which has been quoted by our own judges in the Supreme Court, that we are not, if I remember it, phrase it correctly, that we are final, not because we are correct. We are correct because we are final.
Understand.
So that is why, in last 20 years, curative petition mechanism has come in, because Supreme Court itself has realized that some point of a time, in some context, some decision given, which is, law under Articles 141, 142, which has to be followed throughout the country, it becomes the law of the land interpreted by the highest court. So if some curative mechanism can come in. So they allow now curative petitions also. But somehow, the system has evolved. Life with all this, with passage of time, has become more complex. Your and mine parents and grandparents, in smaller towns, they throughout they used to have 2 or 3 pairs of clothes, and maybe with a pair of shoes, they, completed their life. Now
Correct.
here, a child is born, you buy 10 pair of shoes from day one the child is born. Your own wardrobe is full. So life is complex now. We have ourselves. In pandemic, didn't we realize that we can do and lead life with lesser means?
Yeah, absolutely.
Pandemic taught
Yes,
us.
it taught us.
The fact
Yes.
of the matter is, the more we complicate it, the more means, resources, and the more disputes and litigation would come in. So having that said, life is becoming, as that example you said, that Bombay High Court just said that earlier decision used to be, now what I do, 42 and 46 cases from one side or the other side. So it's that, apart from that, if both the sides have argued the matter with, assisted the judge with more clarity and simplicity, I somehow believe that the outcome would be a better judgment.
Correct. I agree with you. Judgment should be precise. Only, sir, last point, that what do you advise? Because you must also experience when the judges, especially High Court, I am speaking, High Court and Supreme Court, when they see juniors, they sort of, take it granted for themselves to say and get away with anything. So it gets, that young junior, I know one of juniors, he could not come for court for 1 month. He was in
Right.
depression. So what do you advise to them that?
I mean, as legal professionals, because you're ultimately going to, shape up yourself into somebody who is going to fight for the rights of citizens of the country. So you need
Yeah.
not be one so sensitive. If you get browbeaten by a judge, doesn't matter. You have an opportunity later on. Don't take it so much to your heart, and this thing, it's part of it. Even very senior people can get scolded by the judges. And, it differs from there. There is example of some judges who promote juniors so much. So,
Yes, yes, yes,
in
yes,
the
yes.
Supreme Court itself, I will
Fully
give an
encourage.
example. I am not a regular practitioner there, but I am in interaction because my matters go there as well. So I am in interaction with a lot of lawyers there. They have, praises for certain judges so much. For example, Justice Chandrachud here, and he gives such a patient hearing to juniors. So, all kind of people are there, but you have to adapt to the system. Ultimately, we cannot have this thing. You have to find out a way through even a hard judge or a judge who's irritable at that point of a time for whatever reason. Not as within those constraints, you have to perform the best. Because if he's irritable, he's bad, he's bad to other juniors as well. You have to compare yourself with other juniors. And by, when you'll gain seniority, that advantage will be there. That judges will take you more seriously. It's a very human thing.
Thank you very much. Thank you. Thank
So thank you so much for answering that question and for that discussion. Thank you, Sai sir, also for such valuable contributions to this class. So there is this question by Advocate Nilesh Sharma. Mr. Nilesh, would you want to ask this question yourself?
Keshav, you can ask on my behalf, please.
So, sir, Mr. Nilesh says, you had said that pleadings must be simpler and precise, but nowadays we are seeing even in a normal case, the pleading is consisting of minimum of 30 to 35 pages. So how do you decide which particular number of pleading pages is sufficient?
You see, if initially, I'll not say that, as a young lawyer, you can decide that. But I think with the sufficient practice of 1 or 2 years, you will realize what are the main things. My own experience while dealing with, very, very complex matters, service matters, especially when we are challenging rules, constitutional validities, other things before a court of law. In any case, the best of the cases, the most complex, it is 1 or 2 points on which everything turns. So you have to recognize and realize it is those points have to come across. The other are antecedent and supporting facts. Having said that, in the flow chart of the facts that you'll put in, you have to put all the necessary facts which are connected to that issue. Least the judge might think, or the other side may argue that you have suppressed certain facts. Facts need to be there, but you may not elaborate them so much as is, because these days, with one simple fact, I have seen we are not getting into the habit of writing five pages of pleadings on fact was one simple fact. You can reduce that. You can minimize that. I'm not saying that do away with it. You can reduce it, minimize it, use a simpler language, use a more precise and accurate language by which you can minimize it. I can understand you cannot just do away with it. The facts are there, they have to be stated.
So, sir, thank you so much. I hope, Nileshji, this answers your question. And the second part also, which is suggestible always to submit written arguments. So with respect to that, we have very limited time of sir left. And so I'll ask everyone if there is any question, then right now is the best time to ask. So I think that's about it, sir, with the question that have come in so far.
Yeah, hi, sir. I was very attentively listening to all the relevant points being made by you. And I only have one question that in
Please.
case, yeah, so I joined in late, but I've really found this session to be really very useful, instructive, impressive, and I guess it's definitely a knowledge gain summed up. I'm really happy that I did attend this. So there was only one question, that if people are basically, and most of us are into civil and criminal litigation as well, many a times it so happens that you build on a lot of tension and a lot of frustration, though you do not want to. So how would one come out of that?
You can have, your own mechanism. There can't be one standard formula to deal with, even assuming that you are not lawyer, you were in a high profile corporate job, having a lot of pressure, or for that matter, that you were, in some other profession, like let's say in medicine, where people's life depended on your decisions, how to deal with it. Pressures would be there, and we are living in a pressure cooker situation kind of a society, wherein if you have to go ahead with, unless you are your ancestors have left so much of money that you can be very cool, and even for those people to protect their wealth, they have to be on tenterhooks or on lookout. It's a pressure cooker life that we've created for ourselves. Whichever way you look at it, wherever you want to perform well, whether it's a profession, it's business, it's other calling. Do you think just becoming a professor in a university would be an easier thing? There also, there is a continuous pressures, evaluation. Things have changed. We are living, it's a pressure cooker kind of a reality. And some of them are more stark here. You just take an example of politics. You take example of, sports. You take example of fashion industry or example of the film world, they are facing much more pressure. It looks very glamorous from outside, that the final outcome was that. But having said that, you have to, evolve some kind of a mechanism. You need to be a little bit thick-skinned, as a professional lawyer. That in the long run you have to be. So you have to be, I'm not saying that you discard your sensitivity or you don't take it, but it does. I personally feel, even after three decades of putting in this practice, that the client comes in, pays you fees and, offloads all his, problems and difficulties to you. You can't even sleep in the night if that matter is listed before some kind of a court where you can't get relief. So those things are there, but you have to, or your own way, deal with that stress, how you deal with it by spending quality time with your family, with your friends, reading for relaxation, reading, because we are all the time reading. So we kind of get cut off, most of the lawyers, to read some other, light stuff, the things that you always wanted to do. A physical sport will help you very much. A long walk will help you very much. And the best thing to do, especially if you cross the age of 40 or 45, you can pick up some kind of a yoga 3 days a week. That will help you to deal with the stress.
So once again, Pooja,
Yes, sir. So thank you so much. Yes, I got the answer that I was looking forward to.
And you're most welcome. And in any way, if I'm able to help you, it'll be such a pleasure.
Thank you so much, sir. Thank you very much. And Keshav, all thanks to you that you've taken this initiative. And maybe I've logged in for the first or the second time, but I really found it very informative. Thank you so much.
ma'am, thank you so much. Manoj sir, thank you so much, sir. At the end of the day, it is actually, sir, how this initiative, it's a very humble initiative, but sir, it is just the like and the might of such seniors as your good self, sir, who are taking the time out and contributing, sir, their time, which is so very precious, obviously, sir, with respect to so many clients and other obligations that you have. But little bit of that which we get for ourselves and which is there for the development and betterment of so many other advocates, as well as other people. So anyone, I believe, a person who may not necessarily be a person of the fraternity or the legal fraternity itself, even that person, when that person, any professional for that matter of fact, who comes across this session today, I'm quite sure will definitely benefit a lot. I've personally taken my notes.
Okay, thank you, Kesh.
So it was very enlightening right from the moment you answer. Actually, it was. Sir, I'm just sharing, sir, one personal thought of mine also, that how you categorically brought down all the points that you wanted to in this session today. It actually helped me personally also understand how if to effectively convey my point before the court.
Yeah,
And
you're right,
all of
Keshav.
it, sir.
Right. What happens ultimately, our job as lawyers is by and large that involves, communication. First you have communication with the client, then you communicate it to the court, to get the end result. So communication is the key to our profession.
And so we've taken extra time of yours, but we are very grateful to you, sir, from the bottom of our hearts. And I take this opportunity to thank you on behalf of all the participants who are here, who were here, who are not here right now, and all the people who will be able to access this class in the future also. So very, very thank you to you. And sir,
Thank
we're
you, Manoj.
deeply grateful to you.
And thank you, Keshav.
So thank you so much, sir. We're very, very grateful to you, sir, for having conducted this.
Thank you,
Thank you,
Keshav, for giving me this opportunity of interaction with with young lawyers. And it was such a pleasure. I'd love to come back again anytime that you call me.
So we're very, very humbled and very, very grateful to you.
All of you have a nice Sunday. Best of luck.